The other exception has to do with a clarification of what commercially and publicly available means. If any step is required in order to obtain access to a database or any other type of information that may contain, or source that may contain genetic information, then that does not fall within the exception. So if, for example, someone has their Facebook page, but it's set to a setting where you have to be friended in order to get onto that Facebook page, that would not be covered by the exception. It has to be truly available. The type of scenario where you're trolling around the internet more generally, and something becomes available to you. But they went a step further, and they made sure, and this goes back to the specific or deliberate intent provision and privacy exception, is that if you have any intent to acquire genetic information, then even if it is commercially and publicly available, then the exception doesn't apply. So, for example, if you happen to be trolling around the internet, and you find some genetic information, that is covered by the exception. But if you were to, for example, put someone's name into Google, perhaps their name and some other information with the intent of trying to obtain genetic information, even if it's publicly available, even if it's available on a completely open source site, it is not, according to the regs, it is not covered by the commercially and publicly available exception. GINA does not preempt state law, and that's important, particularly for a reason I'll get into in a second. But most states, the vast majority of states, have genetic non-discrimination and/or privacy laws. Most, in fact, almost all were passed before GINA, and because of that, in terms of the substantive protections of those laws, most are more limited in scope than GINA. Probably the most common deficiency is that they're limited to the results of a genetic test and don't include family history, which, as I mentioned, is still the most common form of genetic information that could be acquired. But most of these states do not have limits on recovery. So if you had, for example, a client who had a claim under both GINA and state law, you may want to choose state law if you meet the limits of the statute, because there's no limitation on damages in many states the way there is under GINA. There are other state laws, including in Massachusetts, that cover other forms of insurance that GINA does not. As I said, GINA only covers health insurance and employment, but there are state laws in a number of states that include life insurance, disability insurance, long-term care insurance. And this was already covered a little bit. Massachusetts' genetic discrimination law covers health insurance and employment. It relatively mimics GINA in its language. There's the other provisions in Massachusetts that cover disability, long-term care insurance, life insurance. There's a bill that was just introduced in the Massachusetts legislature a couple weeks ago. I wanted to bring to your attention. It's called the Massachusetts Genetic Bill of Rights. When I checked, it didn't have a bill number assigned to it, had a docket number. But it's an attempt to expand and build upon Massachusetts law with regards to genetic information and protect some areas that are not covered currently by Massachusetts law and certainly are not covered by GINA, areas everywhere from banking and mortgages to other forms of insurance as well. One of the challenges I think we have having passed GINA is educating, and that's part of the reason why I'm happy to be here today, that GINA exists and that it has provisions that offer many Americans additional protections that they're not even aware of. In fact, most Americans' knowledge is actually, according to the recent study, their knowledge about genetic non-discrimination laws and privacy has actually gone down in the last few years rather than up. It is at, in terms of their actual concern, it's at an all-time high. Almost everybody you ask, 3 out of 4 people, are concerned about genetic privacy. They're concerned about genetic discrimination. Virtually nobody actually knows that we have protections in place. Certainly they're not comprehensive, but to the degree that we have protections, GINA is a relatively strong law, and most Americans aren't aware of it, which is part of the reason why we've had only 100 claims, or roughly 100 claims so far, filed with the EEOC since GINA passed. Virtually all, and I'm going to, and I suspect that this will be the case for some time in the future, virtually all of those claims have to deal with the use of genetic information, not with actual discrimination. And I suspect that employers, as they become more and more sophisticated and understanding the law, that may change. But for now, most employers don't have a sufficient understanding of GINA. Their practices oftentimes are in violation of the privacy provisions of GINA. Most employees don't even appreciate that that's the fact, but there's a lot of potential liability out there for to look for that is currently not being addressed. So GINA is the beginning of something. It's certainly by no means comprehensive. It covers only 2 areas, health insurance and employment, but it is not only the first civil rights law passed by the Congress in almost 20 years, but it is the most significant law that we now have covering genetic privacy and discrimination. And we hope it serves the foundation for building upon, but that still remains to be seen as legislatures become a little more tacit in the way they respond. But and we're happy to answer any questions, and we hope the discussion takes a more impersonal way. So.
At this point, we are getting questions.
It mirrors the civil rights laws, so there's no individual liability. It's similar. The framework it builds upon, the definitions are of course new, and the subject matter is new, but the framework of Title II is familiar to anyone that understands, particularly the ADA or Title VII. Well, no, you still have to prove damages. I mean, so that becomes the challenge. Certainly, is a challenge for when there's a privacy violation and no corresponding discrimination. That, of course, can be difficult in terms of showing what the actual damages were. So that remains to be seen how that is addressed in litigation. Well, I mean, they're relatively new. Those cases haven't progressed very far, but to the degree that they have been addressing them, it's been so far largely through attempts through mediation and attempting to get employers to change their policies.
What are the cats and liability in GINA? It doesn't preempt state law, anything contrary to state law,
Yes, I mean GINA. You have a choice. I mean, you have a choice of filing under GINA or under state law, or you can file under both. There's no prohibition on doing so. There's no preemption at all. So you can do under both. I mean, I think, as I said, whether you pursue a state action as compared to an action under GINA is really going to depend, in large part, I suspect, on the facts of the particular case. Because GINA has limits on damages and most state statutes do not, if you do fall within the definition in the state statute, you're likely to at least potentially have a larger reward. But that But as I said, the state statutes definitions are much more limited in that respect. So there oftentimes, as I said, the largest limitation has to do with the actual definition of what is genetic information. And as I said, still today and for the foreseeable future, it will be family history will be the most common form of genetic information. Most state laws do not cover that. The limits on liability under GINA? It mirrors the Title VII framework. So I don't have them memorized because I always look up the table, but the same limitations you see under the ADA, you'll see under GINA.
You said earlier when the whole genetic discrimination is that you had your own anecdotal cases of genetic discrimination. Have there been more cases of actual genetic discrimination? Because it doesn't seem to be a real incentive for anyone to discriminate based on genetics, because genetics often don't tell you much.
Well, that's true to a degree, although most individuals, I would argue, in this country believe that genetic information tells you a lot. Yeah, that's not necessarily true, but and employers certainly are by no means sophisticated in their understanding of genetics, and most of the cases that we had seen and had to do with employers that really didn't appreciate that genetic information indicates a predisposition and perhaps a certain percentage increase of a link, but is by no means dispositive. That's why much of the anecdotal evidence that we saw was really in the health insurance context, where you saw health insurers who wanted to limit individuals, particularly these were individuals with dependents who wanted to either deny them coverage for their dependents or prohibit them from even coming onto the health insurance in the first place.
So if I can throw something in, it's one of the things that makes these statutes, the anti-discrimination ones, unusual from other civil rights laws in that there wasn't rampant documentation of a national problem. And a lot of people have written about that they're more prospective. There was a push from the science community for the anti-discrimination laws, not necessarily the privacy laws, but the anti-discrimination laws, because it was concerned that people were hesitant to get into the research which will push genetics forward without some kind of assurances that there was not this exposure for discrimination. And unfortunately, from what the researchers tell me, is that the passage of GINA, even on the federal level, hasn't opened up floodgates, and everybody's now giving their samples to researchers to do whatever they want to do with them. So who knows so it's a question of where's the public with this? And I think the public is in pockets, and some of the public is heavy into genetics and is pursuing the direct-to-consumer, genetic testing services and posting their whole genomes on Facebook and letting everybody else share it and playing around in it too. And there's other people that would be horrified at that thought.
We saw GINA as an opportunity. I mean, it was an opportunity to pass civil rights protections for a category for which we saw evidence that there was discrimination occurring, but certainly had not come close to becoming ingrained in the social fabric the way other forms of discrimination had. So as we said, it really was prospective in that sense. It was an attempt to stop discrimination before it became rampant, rather than prohibit discrimination that was regularly occurring.
Yeah, so on my optimistic days, when some of these were being proposed, I think of it as, there are people and entities in society that say, we want to do the right thing, just tell us what are the rules, what's the right thing to do, and so that the statute can be looked at as a source of guidance for employers and insurers and people that it's actually directed to.
And that's not to say, though, that genetic discrimination won't occur anymore. And the truth is that compared to other forms of discrimination, the motives for genetic discrimination are often financial, and as a result, they remain in place. And as health insurance costs continue to be an issue for employers, continue to be an issue for the insurance companies themselves, those financial incentives to discriminate will remain.